Hello, my name is Brett Davies. If I had to narrow estate planning and will making down to one word, that word is flexibility. Because you don't know what you'll have when you die, you don't know when you're going to die, you don't know what beneficiaries will be alive, and you don't know what the de facto death duties will be. And they are capital gains tax, stamp duty, and income tax. But you don't know what shape or form those three wild animals will be when you die. So you need to keep your will flexible. We have a problem. If you become of unsound mind, you cannot change your will. Can you use a power of attorney, an enduring power of attorney, a mutual power of attorney, a cascading power of attorney to rewrite a will? No, you can't. You can't use a power of attorney for that purpose. But your local Supreme Court is more than happy to consider rewriting the will, or starting up again and rewriting a brand new will, or altering a will of someone of unsound mind. So let's say in Horsfeld and Horsfeld's case, 2012 New South Wales Supreme Court, the decision has been made that you will go to the court and you'll have the will amended because all the money is going to you as the son, but you're about to go bankrupt. Can you get the will amended so the assets now go to your beautiful wife, who is not going to go bankrupt? The court held in that instance, unfairly in my view, that the creditors should not have their claims destroyed by rewriting the will and having the wife get it all rather than the almost bankrupt son. The court admitted that if Dad was still of sound mind, he would have rewritten his own will in order to leave the assets to the wife, the son's wife, and therefore avoiding all losses to the creditors. Well, they lost on that one, but what about in the similar case in 2012 Queensland Authority Supreme Court in Rematis and Chalamamos? In that instance, the will was amended in order to add a testamentary trust into the will to save tax. Well, that's interesting. And to protect for asset protection, which is pretty similar to bankruptcy rules. So in another case, in the same year, the courts made a decision that they would allow the will to be amended by inserting a testamentary trust into the will, which gave asset protection and also reduced the de facto death duties. And the court there, it said that Dad would have wanted that. He'd done an interim will, or what the children had argued was an interim will, and successfully argued, and therefore it was right for Dad. He would have made a new will himself, putting proper testamentary trust and estate planning in place, and therefore the Supreme Court did step up and make that change. And therefore I find it very hard to distinguish the facts between Matisse and Horsfeld's cases. Now, the question that was sent in to us was, the son is about to get divorced from his wife. His dad is very sick and will die shortly, and he is the sole beneficiary of that will. So let's assume Dad dies. All Dad's assets go to the son, and they're now part of the available assets for the family court to distribute to partly to the son and partly to the wife in a fair and equitable way. Well, that's not what Dad would have wanted. And if Dad was of sound mind, he'd change his will to set up probably some 3-generation trusts, testamentary trusts, maybe some asset-protected 3-generational testamentary trusts, which we used to draft at Brett Davies Lawyers. Now we do it Legal Consolidated. These would get rid of a lot of those problems. The courts could put those powers into the will. Would the court make that decision? Well, again, it depends which court you're going to. In our view, Horsfeld and Horsfeld is not good law anymore. It hasn't been applied in other cases, and therefore we believe that you'd probably be very likely to win at the Supreme Court in order to ensure that the wife or ex-wife or ex-spouse cannot participate in the assets of the dying father. He would have made his own will to have done it that way, and the court should follow suit, and we have found recently that they will do so. So all is not lost. If you're of unsound mind, your family can still come together and attempt to have the will rewritten by the Supreme Court.